Hi, it's Christina with the Sisyphean Journal. I'm responding to mainly the comments on an excellent news piece that I'll link to below, where a lot of the commenters are very justifiably outraged at this district attorney's behavior. At least if she's guilty of what they say she's guilty of, and I get the sneaking suspicion she is, because nobody goes after a DA if they don't have good reason. But I think the absolute take the cake, win, place, and show in public officials not only not doing their duty, but doing the opposite of what they're supposed to do, has to be how public officials handled Kermit Gosnell. For those of you who aren't familiar with it, Kermit Gosnell ran a filthy, deplorable abortion clinic in Philadelphia where state officials were told how horrible it was. They were told about patient deaths. They were told about sick, flea-infested cats roaming around the place. They were told about unqualified staff administering dangerous narcotics when nobody was on site. That knew CPR. They were told about missing and broken equipment. And they're just like, yeah, whatever, it's abortion. As long as women are able to go in and get their abortions, it doesn't matter whether they actually survive them or not, evidently. So in the video I made a couple hours ago, I went over what the Department of Health dropped the ball on. Department of Health is responsible for looking at the clinic. Sorry, that noise is my dog chewing on a bone. If I take his bone away, he's going to sing for me. But at any rate, this is looking at the Department of State, which under the Department of State umbrella is the medical board. And this is going to look at how the medical board really failed. So, and all of this is going to be verbatim from the grand jury report. Below, I will link to the grand jury report. But just to make it easier for you, I've also cut and pasted the relevant sections of, this is hundreds of pages. So I took the relevant sections and I highlighted the most salient points, and I'm going to share them with you verbatim so that you can get a feel for how badly the medical board screwed the pooch on this. The Department of Health was not the only state agency that could and should have shut Gosnell down decades ago. The board's attorneys had ample notice of Gosnell's illegal and reckless abortion practices and of the damage he had done to patients. 8 years before Kanamaya Mongar died, a former Gosnell employee told the Department of State about the illegal practice that resulted in Mrs. Mongar's death. Gosnell had unlicensed workers anesthetizing patients when he was not at the clinic. Yet despite receiving that report and several other serious complaints over the years, the board took no action to suspend or revoke his license. Attorneys for Pennsylvania's Department of State disregarded notices that numerous patients of Gosnell were hospitalized, infected, with fetal remains still inside of them, and with perforated uteruses, cervixes, and bowels. Incredibly, in 2004, Department of State attorneys closed, without investigation, a case reported to the board involving the death of 22-year-old Shamika Shaw. Between 2002 and 2009, Board of Medicine attorneys reviewed 5 cases involving malpractice and other complaints against Gosnell. None of the assigned attorneys or their supervisors suggested that the board take actions against the deviant doctor. In fact, despite serious allegations, 3 of the cases were closed without any investigation. The other 2 were investigated and then closed without any action being taken. One failure to investigate stands out. On October 9, 2002, the Professional Underwriters Liability Insurance Company reported to the State Board of Medicine that it had paid a $400,000 settlement to the family of Shamika Shaw, the 22-year-old mother of 2 who died following an abortion procedure at Gosnell's clinic in March of 2000. The October 9 report is logged in as received by the Department of State's Complaint Office on December 6, 2002. So it took them almost 2 months even to stamp the word received on it. Sorry, that was me. That wasn't verbatim from the grand jury. The next action recorded in this file is a 1-paragraph prosecution evaluation dated April 29, 2004, in which Mark Greenwald, a prosecuting attorney for the Board of Medicine, purportedly summarizes the case and concludes, prosecution not warranted. Here is the paragraph. The underlying malpractice case involved the death of a 22-year-old female following the termination of her 5th pregnancy. Following a seemingly routine procedure on 3/1/02, the patient was taken to the ER at the University of Pennsylvania with complaints of pain and heavy breathing. The patient underwent surgery, but the surgeon was unable to locate any perforation, and the patient died from infection and sepsis. Although the incident is tragic, especially in light of the age of the patient, the risk was inherent in the procedure performed by Respondent Gosnell, and administrative action against the respondent's license is not warranted. Recommendation Z-02, prosecution not warranted. In fact, all of the information in this single paragraph is taken entirely, including incorrect dates, from the insurance company's original paragraph-long report sent to the board in October 2002. And yet, while Greenwald included the irrelevant but pointed assertion that this was the patient's 5th pregnancy that was being terminated, the Department of State prosecutor admitted from his summary the most important information the insurance company had provided. Quote, autopsy report indicated perforation of cervix into uterus. Heirs allege our insured improperly performed the termination procedure and failed to diagnose post-op uterine perforation resulting in sepsis and death. Greenwald's supervisor, Charles J. Hartwell, the senior prosecutor in charge at the Department of State's Bureau of Professional and Occupational Affairs, purportedly reviewed Greenwald's evaluation and approved it on May 14, 2004. Dragging feet, maybe? Hartwell did so, ostensibly, knowing nothing beyond the bare facts that Shamika Shaw died from infection and sepsis 2 days after Gosnell perforated her uterus and cervix during an abortion procedure. Aside from the absence of facts to support the prosecutor's recommendation, logic, too, is missing. If prosecutors are going to forego investigations every time someone dies during a medical procedure with the excuse that death is always a possible risk with any kind of surgery, there is no point in pretending that they are investigating and prosecuting cases against doctors. What makes these prosecutors' inaction even more astonishing is that they did know more than the bare facts included in the board attorney's evaluation of the case. On the same day in 2004 that they decided not to do anything about Shamika Shaw's death, these same 2 prosecutors, emphasis in the original, also closed the investigation into the complaint brought to the Department of State more than 2 years earlier by Marcella Stanley Chong. That was the complaint that had alerted the Board of Medicine 8 years before Karna Maya Mangar died to almost all of the same violations revealed by this grand jury's investigation. In December of 2001, Marcella Stanley Chong had filed a detailed written complaint with the Pennsylvania Department of State. She informed the department investigator that Gosnell was using unlicensed workers, including herself, to give IV anesthesia to patients when he was not at the clinic, that his facility was filthy, that 2 sick flea-infested cats roamed freely in the procedure rooms, vomiting throughout, that Gosnell ate in the procedure rooms, that the autoclave used to sterilize instruments was broken, that he reused single-use curettes, that there were no licensed nurses at the facility when IV anesthesia was administered, that Gosnell performed abortions on underage children against their wills if their mothers asked him to. Chong told the Department of State investigator that she thought a second trimester patient had died at a hospital after Gosnell performed an abortion on her. And she said that she had seen patient files in which he prescribed 90 Percocet tablets for a patient 1 week and then again 90 more tablets the next week. She gave very detailed information about the files, what she saw and when. She provided the name of at least 1 patient and suggested that the investigator take a look at her file. Chong wrote that any of the other clinic workers except one named Jonathan would be willing to confirm her information. But the investigator with the Department of State did not question any of the other unlicensed workers. And the Board of Medicine did not use its subpoena power to obtain files to substantiate Chung's complaint. No one even asked the facility for its files. The investigation consisted of 3 interviews, one with Gosnell, one by telephone with another doctor, Dr. Warren Taylor, who said he performed abortions at the clinic in 2001, and one with the pharmacist 2 blocks from the clinic on Lancaster Avenue. Dr. Taylor confirmed some of what Chong said. Gosnell, according to the investigator's report, did not directly contradict many of Chong's allegations, but made excuses instead. He also told outright lies that could have easily been disproved. Gosnell claimed that he did not use Schedule II controlled substances for anesthesia, even though he did. Gosnell asserted that he always administered the anesthesia, something any of the clinic workers would have refuted. He acknowledged that he let his patients choose their own anesthesia for mixes entitled Heavy, Twilight Sleep, and Custom Sleep, names that should have been a tip-off that someone at the clinic was heavily sedating patients. Gosnell declined to provide a written response to Chong's allegations. Still, no one at the Department of State probed further to see if one of Chong's most serious contentions, that unlicensed employees were administering the anesthesia with no medical professional present, was true. The investigator did not request to see any files. His notes indicate that he visited the area of Women's Medical Society, but there is no indication that he asked to go in. He conducted his interview of Gosnell at a regional office in King of Prussia rather than at the doctor's office, where he could have confirmed many of Chong's allegations firsthand. Even with this superficial inquiry, the investigator recommended further action. He concluded his report by suggesting that the Department of Health be notified of Chong's complaint, which, he wrote, alleged health issues at Women's Medical Society that may be detrimental to staff and the public. The investigator made it clear that he had not notified the department when he submitted his report. According to the files turned over to the grand jury by the Department of State, no further action was taken until April 29, 2004, nearly 2 years later, when Greenwald, the same prosecuting attorney who recommended against following up on Shamika Shaw's death, also recommended closing the case on Chong's allegations. With serious allegations that Gosnell was allowing unlicensed workers to administer IV anesthesia, that he was overprescribing Percocet, and that he was violating many provisions of the Abortion Control Act, Greenwald did not subpoena any records from the clinic. He did not send the investigator back to talk to the other unlicensed workers, as Chong had recommended. He simply concluded that the allegations had not been confirmed and recommended no prosecution. And Hartwell, the senior prosecutor in charge, agreed. There can be no claim of a communication gap or of a case simply falling through the cracks. A single Board of Medicine prosecutor and his supervisor disposed of both the Chong allegations and the Shaw case at the same time. If nothing else, the board prosecutor should have contacted the insurance company to find out what its investigation had revealed that prompted it to settle the malpractice suit in the Shaw case. With the call to the Department of Health, the board's attorney could have known immediately of at least one other prosecutable offense. Gosnell violated the Abortion Control Act by not reporting Ms. Shaw's death to the Department of Health. For this offense, the Board of Medicine had the authority to suspend or revoke Gosnell's license. The state prosecutors, however, clearly had no interest in investigating Gosnell, much less holding him accountable for the crime spree that he called a medical practice. In September 2005, a plaintiff's attorney sent a copy of a malpractice complaint he had filed against Gosnell to the Department of State. The case involved a patient we will call Alice. She had suffered a seizure after Gosnell administered anesthesia to her in a procedure room as he prepared to perform an abortion in March 2005. Alice had notified clinic staff that she was undergoing methadone treatment and that she had received her daily methadone dose before the procedure. The lawsuit alleged that despite this warning, Gosnell gave her medication that was clearly contraindicated for people on methadone, triggering a seizure. According to the complaint, Alice told Gosnell to stop the medication when she started to have a reaction, but Gosnell ignored her and continued the IV injection. Alice began to convulse and fell off the procedure table, striking her head. A companion who had accompanied Alice to the clinic was summoned to the procedure room to assist. He found the patient naked and convulsing on the floor and asked that someone call 911. When Gosnell denied his request, the companion attempted to leave the clinic to summon help. The complaint alleges that the doors were locked and the staff refused to let him out. As a result, Alice convulsed for an hour while Gosnell and the staff refused to allow her companion to leave the clinic to get help. Finally, Gosnell permitted the companion to go to get some methadone to administer. The additional methadone stopped the convulsions. On May 4, 2006, David Grubb, another prosecuting attorney for the Board of Medicine, recommended closing the file without any investigation or prosecution. Grubb closed the case without interviewing Alice, her companion, Gosnell, or any of his staff members. Hold on, let me enlarge this there so I can scroll down and read it. Gosnell applied to renew his medical license in December 2008. He indicated, as he was required to, that a civil malpractice lawsuit had been filed against him in November 2008. The lawsuit was brought by Dana Haynes, who had gone to Gosnell for an abortion on November 11, 2006. The complaint alleged that Gosnell had performed the abortion in a reckless manner, tearing Haynes' cervix, uterus, and bowel. It asserted that after performing the botched abortion, Gosnell failed to call an ambulance and instead kept her waiting in the clinic for 4 hours, bleeding and in severe pain. Haynes accused Gosnell of placing her life in jeopardy in order to cover up his negligence. The complaint stated that Haynes bled excessively for a long time and had to be hospitalized. At the hospital, doctors discovered that Gosnell had not completed the abortion and had left fetal parts inside Haynes. Her injuries required extensive surgery. On April 20, 2009, a prosecuting attorney for the Department of State, Juan Ruiz, recommended closing the file without intensive review. In fact, without reviewing anything but the complaint. With no other facts and no attempt to determine any other facts, Ruiz included, the important allegation is that the referenced above, plaintiff contends she suffered permanent injuries due to respondent lacerating her small intestine during an abortion. Barring a pattern of conduct, which does not exist in this case, this would be at most considered simple negligence or incompetence, as this would be a case of surgical site injury. Ruiz wrote that no pattern of conduct existed in this case. But how could he possibly know that? He did not look at Gosnell's history. A simple database search conducted by the evaluator from the National Abortion Federation before she visited the clinic in December 2009 showed that at least 5 women before Haynes had successfully sued Gosnell for perforating their uteruses. Gosnell or his insurers had paid over $1.7 million to these women or their families. One, Shamika Shaw, had died from her injuries, as Ruiz should have been aware. Ruiz claimed that he had no way to find this information. If that is true, it is appalling. The database used by the Abortion Federation's evaluator, the National Practitioner Data Bank, NPDB, is designed for use by state boards of medicine to assist them in quickly and easily identifying and disciplining medical providers who engage in unprofessional behavior. The basis for Ruiz's decision that Gosnell had no history of perforating uteruses would have been quickly dispelled had he simply checked the NPDB's information. Even if the prosecuting attorney did not have access to the NPDB database, Ruiz should have been alarmed by the information in the Department of State's own records. Shamika Shaw had died from the same injuries alleged by Ms. Haynes. Marcella Chong, who had no monetary interest, had spelled out essentially all of Gosnell's criminal practices to the department. The woman we have referred to as Alice and her companion had accused Gosnell of locking the companion in the clinic to prevent him from getting medical help for Alice. Accordingly, when Ms. Haynes alleged that the doctor did not summon help for her, but left her for 4 hours bleeding and in pain, that should have at least warranted a phone call to Ms. Haynes. Yet Ruiz apparently did not even read the complaint carefully. He claimed before the grand jury that no one investigated the allegation that rescue was not called for 4 hours because it was not contained in the legal filing in Ms. Haynes' medical malpractice suit. In fact, it was. Prosecuting attorney Ruiz testified that it was unfortunate that Haynes' attorney did not lay out all the facts in that complaint. Even leaving aside the erroneous claim that the complaint did not include an allegation about failing to call an ambulance in a timely fashion, the prosecutor's testimony points out a serious flaw in the Department of State's procedures. The department's disciplinary responsibility should not depend on the quality of a plaintiff's presentation. At least some independent fact-finding should take place. At a minimum, the complainant should have been interviewed. Had the prosecutor asked an investigator to call Ms. Haynes, he would have learned what Inspector Gillespie did a few months later, that in Ms. Haynes' case, Gosnell had locked her family members out of the clinic, preventing them from discovering that she was bleeding profusely after a bungled procedure and from summoning help. Ms. Haynes said that no one counseled her about the abortion. At 7:45 p.m., when she was taken to the procedure room, she called a cousin to tell her that she would be ready for pickup shortly. In the procedure room, one of Gosnell's sons inserted an IV and administered anesthesia. Ms. Haynes said she remembered Gosnell entering the room and talking to his son, but everything else is a blur. When she woke up, she was in the hospital with her family around her. Ms. Haynes told the investigator that the clinic staff refused to let her two cousins come inside the building when they arrived around 8 p.m. to pick her up. This one interview established at least two serious violations that should have prompted disciplinary action by the Board of Medicine: Gosnell's routine failure to counsel abortion patients and the use of unlicensed employees to perform work for which they were unqualified. The evidence that clinic staff locked Ms. Haynes' cousins out of the facility to cover up the fact that Gosnell had seriously injured the patient and thereby prevented her getting help was even more serious. Investigator Gillespie's interviews with Ms. Haynes' cousins confirmed that they had been purposefully locked out of the facility for over 4 hours. Finally, sometime after midnight, the cousins threatened to call the police if they were not allowed into the building. A clinic employee then told them to wait a minute and eventually admitted them. Once inside, the cousins declined the workers' request that they wait to speak to Gosnell and demanded to see Ms. Haynes. The worker escorted them to the back of the building, where they found Ms. Haynes by herself, lying in a recliner, with no supervision, no monitoring equipment, and no pants. She was covered with a throw blanket, and there was blood on the floor around her. She was slumped over and was completely unresponsive when they tried to arouse her. Gosnell appeared about 5 minutes later. He told them that she was heavily sedated because she had just had the procedure, which they knew was false because of Ms. Haynes' phone call at 7:45 when the procedure was about to start. He told them that there had been complications and that he had been unable to remove the entire fetus. He insisted that there was no need to call an ambulance, but they demanded that he do so. At the hospital, Ms. Haynes was told that Gosnell had left most of the fetus inside her, that he had cut holes in her cervix and bowel. She required a large blood transfusion and remained hospitalized for 5 days. Had investigators from the Department of State pursued Ms. Haynes' complaint and spoken to Karima Cross, she could have told them what she told the grand jury, that Gosnell did not call the ambulance because he wanted to keep trying to complete the abortion. He had already removed the patient from the room once, performed other procedures, and brought her back to try again. Cross knew that the doctor had punctured something. Had the cousins not threatened to involve the police, Gosnell would undoubtedly have brought Ms. Haynes back into the procedure room for at least the 3rd time rather than summon an ambulance. In the end, none of this mattered as far as the Department of State was concerned. No one thought Ms. Haynes' complaint was worth investigating. The grand jury is convinced, based on the number of state prosecutors who failed to take action against Gosnell, on the fact that the prosecutor's supervisors uniformly approved recommendations not to take action, and on the testimony of prosecuting attorney Ruiz that the problem does not lie just with the individual attorneys. The various prosecuting attorneys who handled the complaints against Gosnell seemed either unaware of or unconcerned about the content or even the existence of previous complaints. Ruiz, for example, when asked how many complaints against the doctor had come in, said that the department had been notified of only 2 lawsuits involving Gosnell. Ruiz's supervisor, Carrie Maloney, apparently shared the same misunderstanding regarding the number of complaints. Maloney is quoted in a March 3, 2010 Philadelphia Inquirer article stating, "In my experience, 2 cases in 8 years is not a lot. The Department of State turned over 7 complaint files on Gosnell to the grand jury. One was from 1990, another from 1992. No file was produced for an 8th complaint, an allegation from 1983 that Gosnell had no malpractice insurance. Our review of the files showed that some prosecutors were aware of all previous complaints against Gosnell. These files included printouts listing the file numbers for the earlier complaints. Clearly, Greenwald, who handled Shamika Shaw's case, also knew of Marcella Chong's allegation. He was assigned to that case as well, though this did not stop him from closing the Shaw case without an investigation. The department's prosecuting attorneys never put the pieces together about Gosnell because they did not bother to consider prior complaints. Had any of the prosecutors properly investigated, perhaps they would have understood the magnitude of Gosnell's recklessness. The Department of State only pursued allegations aggressively when the case was very public or when the complainant knew somebody. The complaints relating to Gosnell's abortion practice were serious. The harm he inflicted on patients was substantial, and his routine included the wanton killing of babies outside the womb. Yet even a 22-year-old woman's death did not warrant an investigation, according to the Board of Medicine. It is curious, therefore, that the only complaint against Gosnell that did lead to any kind of disciplinary action by the board involved a non-certified physician's assistant who treated a child for pink eye in 1990. As it happens, the child's grandmother, the complainant, worked for the Bureau of Professional and Occupational Affairs. The next time state officials acted was 20 years later when Gosnell was in the news. After law enforcement asked the Department of State to participate in the February 18, 2010 raid on Gosnell's clinic, Gosnell and his facility received extensive newspaper and television coverage. With the spotlight on them, state officials finally conducted a thorough investigation. So, top that, anybody. This was appalling.